Okay, everybody's talking about Silicon Valley Bank and what the implications are for startups right now, especially those that have limited access to funds and need to make payroll. And I wanted to share some thoughts on what it means for startups when it comes to immigration, US visas, and green cards, especially for founders and employees at early stage technology companies who are immigrants. Okay, so the first thing I want to cover is payroll and making payroll in a couple of weeks. So you absolutely have to talk to your corporate attorney if you have any concerns about making this next payroll, because many states are very strict, and California is one of those, for example. So this interlays with federal law and H-1B employees because you aren't allowed to bench H-1B holders. So if somebody is in the United States and they are your employee and they're on H-1B status and working for you, you can't just like furlough them and not pay them while they're sitting around in the United States. That's a no-go. So one thing that we can do in that situation is help you amend their H-1B for part-time work. We've gotten H-1Bs approved for as little as 5 to 15 hours a week of employment. So I want you to know an H-1B does not have to be for a 40-hour-a-week job. If you want to keep people employed part-time to extend your runway, it is possible to do that even for immigrants on H-1B. You just have to be proactive. You do not have to wait for USCIS to make a decision. You can have the new terms of the employment kick in as soon as USCIS receives the new H-1B petition, if they're currently in H-1B status. So that can be very, very helpful. Okay. Next up, H-1B season. We are in the middle of it. We're doing all these registrations for startups right now. Our firm actually ran out of capacity to help new clients. And the government is accepting new H-1B registrations until the end of next week, March 17th. So what does this mean if you're a startup and you're putting people in the H-1B lottery? Well, the first thing is you don't actually have to employ them on H-1B status until A, they're selected in the lottery, which we'll find out about by April. B, you actually file an H-1B petition for them by the end of June, when the deadline typically is. C, it gets approved. D, they're actually in H-1B status. The earliest time would be October 1st. And E, I guess, would be you don't even have to do a change of status, even if somebody's in the United States. We have OPT holders from India and China who, if they get selected in their first round of being on the H-1B and they're like, no, I want to save my H-1B until later for when my employer is ready to sponsor me for a green card, they choose to seek their H-1B through consular processing to put off and delay the start date until they're ready. So you can use that as a tool as well. And just because somebody has an H-1B visa doesn't mean they have to come into the United States and start working for you. So if you do all that, they get approved for the consular process and they have a visa, you could even tell them, hey, you know what, why don't you end up coming and moving to the US in March of 2024 instead of October of 2023. So there's a lot of flexibility. Another piece of flexibility you have for anybody who is selected, because I know founders really, really value their early stage team members and want to support those people to live their best lives, right? So you can also set the terms of the H-1B employment for anybody who is selected in the lottery. So the time to do that is in Q2, like April and May, when your immigration lawyer is preparing the full H-1B petition. You can have a range of hours. You can have them living in a cheaper location and doing their job there. There are many ways to be proactive and be able to get an H-1B on terms that are comfortable to your company based on your funding and where you are at. Another question we have is, in some immigration situations, people need evidence of employment, and typically they would provide pay stubs. So in the case of somebody who maybe needs to prove they're working for your company and for whatever reason the most recent pay stub isn't available, you can work with your lawyer to think about the timing of, when you need the documents by. Maybe you can wait, or maybe you can do it with a set of earlier documents. But also you can write a letter. You can have an employment verification letter from the Human Resources Department. You can have a letter from the CEO or the CFO. There are many ways, if you need to do it for immigration purposes, to prove that somebody is legally working for you. Okay. Another topic that I wanted to look at, Okay, so now I want to talk about layoffs. So if you're thinking of furloughs, of laying off individuals, of decreasing people to part-time work, to extend your time runway while you're waiting for this whole receivership thing to play out with Silicon Valley Bank, it can really be frustrating because maybe you even conserved your cash so that you didn't have to lay people off in fall, which would be amazing. But here we are, and you need to know about the implications of layoffs. So if you're laying off international students, they have maximum numbers of days of unemployment that they can have in OPT and STEM OPT. But even individuals in OPT are allowed to have unpaid internships and volunteer. There's also strict rules about what qualifies as an internship if it's unpaid. But there are limits that A, they need to keep in mind, but B, you could potentially work with to help them. If you're laying off somebody in H-1B, L-1, O-1, those individuals typically have a 60-day grace period, by which time, if they haven't figured out another status like a job transfer or a green card, they would have to leave the United States. That is their obligation to leave on time, but you do have a cash obligation as an employer, which is they can seek reimbursement for like a one-way return ticket back to their home country. So that's a place where you would have to potentially extend a little bit of cash to cover your obligation there. That can be really hard for people for a lot of reasons. But as a founder, if you want to support your friends and employees, if you have to lay them off and they're on H-1B, they might qualify for an O-1, and there's ways for you to help them with their immigration status, still not necessarily sponsoring their visa, but if they could qualify for an O-1, you can write a letter of recommendation for them. You can help them get media or publicity showcasing the work they did for your company so that they can build up those requirements for extraordinary ability. That can be super helpful to people to have their immigration security for the future. Okay. If you end up doing layoffs, that can affect the PERM process for an employment-sponsored green card for individuals at your company. So please keep that in mind and work closely with your corporate immigration lawyer to do so. We counsel, our team at Alcorn Immigration Law counsels HR and people ops and leadership at startups all the time to make those types of decisions and get the information specific to your company. Okay, now I want to talk about startup founders and O-1s and self-petitioning and how to stay in the United States, regardless of how much money may or may not be in the bank. So we have some visas that are very, very valuable for startup founders and early stage team members. They are the O-1 visa for extraordinary ability, as well as the EB-1A green card for extraordinary ability, and the EB-2 national interest waiver green card as well. All of these now allow for premium processing. It's 15 days for the EB-1A and the O-1A, and it's 45 days for the EB-2 NIW. All of these allow for, well, the green cards allow for self-petitioning. The O-1 can be filed by an agent, but all of them can encompass the possibility of working at multiple places, both as a W-2 employee and a 1099 contractor. Being a startup advisor, there's many types of legal income that you can have access to once you hit certain milestones in those processes, if we set them up right from the beginning for you. So that can be very, very, very helpful. And we're actually having a webinar on later this week to talk about EB-1As and is it right for you? And so I'll put that link in the YouTube window so that you can check it out. Really quickly, the EB-1A is based on past accomplishments. The EB-2 NIW is based on your promise of future accomplishments. If you were born in India or China, or don't have a priority date that might become current soon, most people in that situation would want to be in the EB-1 category because it's faster. Most people who are not subject to those green card backlogs, so people born in Europe or South America, they would typically go for an EB-2 NIW because it's easier and about the same speed. The green cards take about 2 to 3 years. The visas take about 6 months. If you were laid off and you're trying to get an O1, you need to file it before the end of that 60-day grace period to maintain your status in the United States. You could also even potentially file a green card within that 60-day window if you're already in the United States as well. One thing that all of those self-petitioned options have in common is there is no requirement for any VC funding, and there's no requirement for any money in your bank account. So if all the money disappears, it doesn't matter, because what the United States values as the requirements for those visas and green cards is completely separate. A past award of VC funding can be helpful, but it's not required, and you don't have to have all the cash available to qualify. We can use media coverage. You can judge hackathons or pitch competitions. You can be in a startup accelerator or incubator. You can write articles. There are a lot of ways to qualify that have nothing to do with money. In fact, my last TechCrunch article this week was about how you can do a lot of the activities to build up your credentials for these without legally meeting the definition of work in the United States at all. So there's a lot of creative options there for people. Okay, so now, just a note for aspiring founders who want to come to the United States. One of the things that SVB had as a product that was cool for early stage founders who were in other countries and created a Delaware C corporation online through a service like Stripe Atlas or FirstBase. So SVB allowed people without a physical presence yet personally in the United States or a social security number to be able to set up their bank accounts. There are other banking products that allow this for US startups like Delaware C corporations. So we're curating a list of where that's possible. So you're welcome to reach out, and we'll get you those updated details. If you need a social security number as an international person who wants to come to the United States and set up a startup and start working, the fastest way, if you don't have a visa yet, is to get an O1. You could legally incorporate your company. The company could be involved in the setup for your O1 visa. You could come here, you could get a social, then you could open a bank account, and then you could get funding. So there is a way to do it. It makes the funding slower, but it is possible. But I think that there's going to be a lot more solo founders moving forward. And even with all this AI, right, like there's going to be a lot of companies that can exist with way fewer employees. So having a big payroll, is not a requirement either to get some sort of startup founder type of visa or green card in the United States. So let's see. In conclusion, I know it's a super challenging weekend. Everybody's talking about this. Everywhere I walked in Palo Alto today and yesterday, I heard chatter about SVB in the background. It's a really big deal. We're going to be on pins and needles seeing how everything will turn out. But the thing that I have faith in is founders and your grit and your resilience and your determination and your drive and your vision for how your technology or service or product would be part of a better world. So I have faith in you and your creative potential, your determination. If this video and these resources can do anything to at least soothe you a little bit, that you do not have to worry about your immigration this weekend, there are tools, there are experts, there are options, there are things we can do. I hope that can be of service and of value to you. The United States needs you. The national security policy of the most recent two presidential administrations, albeit they from different sides of the aisle, both agree that having entrepreneurs, especially in the STEM fields, is critical for America's leadership in innovation in our global economy. And so I know you can do it. I hope you stick with it. And if you need any help or support at all with the immigration, Alcorn Immigration Law is absolutely here for you. We have that webinar coming up this week. And please keep going. I believe in you. And thank you for all you do and your dedication to your team.